Testing.
Yeah, I can take pictures. Cool. Yeah.
Good afternoon, ladies and gentlemen. Thanks for coming out on a Friday afternoon. Kudos to all of you for taking time out of your day. I think you're going to find it well worth your time. We have a couple of terrific people up on the stage that we're listening to. I'm just going to offer a few brief introductory remarks. I'm Kim Shield. I'm a professor of philosophy at the University of Wisconsin-Stout. I'm also the director of an organization called the Center for the Study of Institutions and Innovation. And what we do is support the civil liberties work across the state at campuses. So we're working with about 20 universities and colleges, both public and private, across the state to promote the discussion of civil liberties. And of course, course, one of the most important one of those is free speech. That's our topic for today. So Ripon hosted our Board of Advisors meeting today, so thank you to Ripon for hosting and Professor Steve Martin for organizing that. So we brought Professor Strossen to talk with us at a board meeting and to do this event this afternoon. So let me talk about these two. I'll start with Professor Strossen. It's very difficult to know where to start. She's an extremely accomplished person. I'm just going to hit a few highlights, otherwise we would spend the hour me just talking about all the wonderful things she's done. She's a graduate of Harvard and Harvard Law School. She started out practicing law in Minneapolis. She went on to New York City to practice law. She eventually became president of the American Civil Liberties Union, 1991 to 2008. She currently is the John Marshall Harlan II Professor of Law at the New York Law School. She writes, teaches, and advocates on topics in constitutional law and civil liberties. She has served on the advisory boards of many national and even international organizations. She's received dozens, literally dozens, of major scholarly, activist, and legal awards. She has done literally thousands of presentations, both in the United States and abroad. She's written about 300 scholarly and general interest publications. She's made hundreds of media appearances. And to top it off, she's a member of the Council on Foreign Relations. Holy cow. She's an academic superstar, if there ever was one. Her most recent book is the subject of our next hour. The title of that book is Hate, Why We Should Resist It with Free Speech, not Censorship. It's published by Oxford University in May 2018. She has been on a speaking tour, virtually non-stop across this country and elsewhere since it came out. Here's a quote from University of Chicago law professor Jeffrey Stone, who's probably a top 5 constitutional law scholar in the country. In his foreword to the book, he writes, Strossen stakes out a bold and important claim about how best to protect both equality and freedom. No one can address this issue in the foreseeable future without taking on this formidable and compelling analysis. It lays the foundation for all debates on this issue for years to come. To spice up today's discussion, Professor Strossen suggested a kind of interview-type format. So, Professor Martin very graciously agreed to serve as the foil in some way for our discussion here today. Many of you know Professor Martin. He's a professor of communication and chair of the communications department here. He's obviously a good fit for Ripon, as he's a graduate of the place. He completed his MA at Colorado State. How many of you knew that? Completed his PhD at
Penn State.
Penn State? Wow, pretty good. He's won awards for his teaching excellence and scholarship. He's written articles and book chapters on free speech, political rhetoric, and more. So with that brief introduction, I turn things over to Professor Martin.
Thanks, Deb.
Should we make sure these are working?
Is that a good
I
volume?
hear a little bit of an echo.
Oh boy.
Yeah.
Does anybody know the sound system to turn it back down a little bit? Do you know it? Okay. We had it set before, but maybe it's not so.
Yeah. Sorry.
Yeah, we've got 3. There's a number on the back on the table.
Can you speak again?
Okay.
Testing. 1, 2, 3.
Better?
That's great. Thank you so much. Yeah.
Well, thanks for coming, Nadine. We're just going to have a conversation, actually, and that's the format that we thought would be best suited to achieve this. So I think before we start having any kind of conversation about this topic, we have to get some definitions down. So could you just define for us what hate speech is, what people mean by it, and talk about, especially from a legal perspective, what that means, if anything?
Absolutely. So first of all, I want to thank Tim and Steve for their hospitality, and thank all of you for spending your precious almost weekend time here. And I don't mean to be impolite to you, but I'm going to answer you by addressing the audience because we're having the conversation with this lovely audience. The term hate speech I actually put in quotation marks throughout my book to underscore the fact that it is not a legal term of art. The United States Supreme Court has never defined a category of speech based on its hateful or hated content and said speech with that message or viewpoint is unprotected under the First Amendment. So it's different from something I know many of you have heard of, which is obscenity, which is a constitutional law term of art. The Supreme Court has defined a certain category of sexual expression, a complicated definition. If you satisfy that definition, the speech is labeled obscene and it's completely unprotected by the First Amendment. The way we use the term hate speech in everyday speech really comes in two flavors, Steve. Flavor number one is that, and mark my words, if you pay attention to the media, I'm sure you'll concur with my observation. People use that term to denounce and stigmatize whatever speech or ideas they hate. So on some college campuses, the words T-R-U-M-P on a t-shirt or the letters or on a cap have been denounced and attacked and protested as hate speech. In some venues, Black Lives Matter activism has been denounced as hate speech. In other places, Blue Lives Matter has been attacked as hate speech. On some campuses, even the phrase free speech has been attacked as hate speech. So basically it comes down to whatever idea the person using that word hates. Now the way I use the term is the second flavor in which it tends to come in our popular culture, and that is, and what I think the core that people really are aiming at, and that is speech that conveys hatred or discrimination or stereotyping on the basis of characteristics that traditionally have been the basis for discrimination, including race, religion, gender, sexual orientation, and so forth.
That would lead me to a follow-up then. Do you think that there are any tangible negative harms of that second flavor of hate speech?
Absolutely. You know, I'm not somebody who's going to say, oh, you know, sticks and stones may break my bones, but words will never hurt me. That is not factually the case. I can speak from experience. I've been subject to vitriolic, anti-Semitic, and misogynistic, and anti-civil libertarian hate speech, and I know. I describe in my book that the first time I was subject to a really vitriolic, out of the blue, stunning anti-Semitic epithet, I still remember it so vividly. And I was fairly mature at the time and in a very privileged and powerful position. I had graduated from a pretty good law school and I was working at a pretty good law firm in New York City, and I was absolutely stunned into silence, which is a very rare occurrence, as my husband can attest. I say that with a smile, but so one of the harms is that there can be a sensorial impact on the person who, or the groups who are disparaged by the speech. So in that sense, there's no free speech concerns on both sides. There can be psychic injury, there can be emotional injury that can have physiological impacts, which have been documented by very serious scholars. So the reason why our parents, at least in my case, told us sticks and stones may break our bones, but words will never hurt us, was not to describe a factual reality, but to exhort us not to let the words hurt us, right? It was to say, you can rise above it, you can be resilient, You should look down on the person who has those hateful, prejudiced attitudes rather than letting somebody like that make you feel small. By that, I do not mean at all to blame the victim, but if we want to be dignified and equal and empowered, there are strategies that we can use, including psychological training and other kinds of education.
Are there some ways, though, that we must be able to draw a line at some point between what we might be defining as hate speech or talking about as hate speech and crossing into intimidation or harassment or threats?
Exactly.
Is there a legal distinction there?
And I've been studying and teaching and writing about the First Amendment for so many years, and yet I learned new insights and new appreciation for the common sense approach of our First Amendment law. I appreciated it in a richer way because what I was trying to do was take this incredibly complex body of law. We each teach full courses and could teach probably 2 years nonstop with all of the cases. But without too much oversimplifying, I was able to appreciate that our free speech, all of those complicated rules, can really boil down into two core precepts. One is when there is not a sufficient rationale for censoring the speech, and the other is when there is a sufficient rationale. So I've already alluded to when there is not a justification, and that is when the only reason is because of dislike, disagreement with, hatred of the content, the viewpoint, or the message, or the idea. That is never a justification for censorship. There the court has said, and I agree, if you hate the idea, then use your own free speech rights. Either ignore it, or answer it back, or refute it, or take some other action, but don't suppress it. The corresponding principle, though, is when you get beyond the content of the speech and you consider its context, then speech with a hateful message, or for that matter, any other message, may be censored and should be censored if in the particular context the speech directly causes certain specific, imminent, serious harm. And the only way that you can prevent that harm is by punishing the speech. And you gave one good example of that, Steve, which is intimidation. Sometimes the legal term for that is a true threat. And why do we lawyers say true threat? It's to distinguish it from the rather looser way that we use the term threat in everyday speech. So I've heard many students say, I feel threatened by the fact that Milo Yiannopoulos is going to be on my campus. I feel threatened by the fact that Brett Kavanaugh may become a Supreme Court justice. And, people can feel very upset and negative sentiments as a result of those kinds of removed, generalized threats. But that would not be a justification for suppressing those ideas. A true threat is when the speaker intends to instill a reasonable fear on the part of a specific audience members. It has to be targeted to one person or a small group of people, intends to instill a reasonable fear that they are going to be subject to violence or other kinds of harm.
You've got a little bit into the next idea here. So your latest book argues that we should resist the urge to censor any kind of hate speech and instead should address it and counter it with more speech. And that sounds great in theory. Could you give us some practical advice to how we can do that, especially in the context of a college campus?
Exactly. And if I can even amplify on the importance of that question, which takes up one chapter in my book, this book is an anti-censorship book to a very significant extent, but to at least as significant an extent, it is an anti-hate book. The only verb in the title is resist. This is a call for resisting hatred and stereotyping and discrimination. And I am absolutely convinced that the only effective way to do that is not through suppressing those ideas. If there are people in our society, and sadly there are people in every society who are haters and discriminators, I want to know who those people are. I don't want to just banish them to the dark corners of the internet where we're not going to be able to monitor them to make sure that they do not let their hateful ideas erupt into hateful or discriminatory or violent conduct. I want to have the opportunity to persuade them to abandon those ideas, to persuade other people not to adopt those ideas. And basically, if you look at, as I did in my book, the experience of other countries which for decades have been outlawing and severely punishing hate speech, they have done no better. In fact, I would say far worse than the United States has in terms of countering actual discriminatory conduct and violence. And I am the first person to say we have so much work ahead of us in this country. That's why I say this is basically a cry, an urge for us to resist hatred, and I'm explaining what I think is the most effective way to do that. But I don't know how many of you follow what's going on in other countries, comparable democratic countries. There have just been virulent outbreaks of violence against Jews, against Roma, against immigrants, against refugees, against Muslims in all of the European countries, including the ones that most strictly outlaw hate speech. Germany being a good example. There was just a story in the New York Times this week about the resurgence of neo-Nazi parties. And speaking of which, in all of these European countries, expressly racist parties in country after country have been gaining substantial support in elections. Germany's last election, an expressly racist party got 13% of the vote nationwide. Sweden is the most recent example where this happened. So, you know, I'd be happy to say more about different kinds of speech that people can engage in, but I want to make another point besides the speech, if I may, Steve, because we should not take for granted and we should never underestimate the importance of passing and meaningfully enforcing laws against outright discriminatory conduct and discriminatory violence. In this country, we have come a long way, but we have much unfinished business. And part of the problem of focusing on words, which to me are the most superficial manifestation of a deep-seated problem. I think we have to deal with the roots of the problem, the attitude, and also the manifestations of the attitude in terms of actual discrimination. So at the federal level in this country, we still don't have a law that makes it illegal to discriminate on the basis of sexual orientation or gender identity. Shouldn't this be a priority? That major corporations and employers and landlords and so forth can refuse to hire somebody for blatant homophobic discrimination. And then in other areas where we do have laws, voting rights, I think, being the quintessential example, because if you don't have the right to vote, then you're being deprived of political power and your ability to influence every kind of policy on every kind of social and racial and other issue of justice. And yes, we have a wonderful Voting Rights Act, but that has been undermined by Supreme Court misinterpretations, and it also has been undermined by voter suppression laws that have been passed by states and local governments all over the country. So I really feel that we have to, you know, stop focusing so much on speech and not allow our efforts to be deflected from what I think are more constructive ways to remedy and prevent discrimination.
can I bring it down to a
Yes.
college level now?
Yes.
We've got a lot of students in the audience. Some of them are in my First Amendment class. And one point that I made very clearly in the first week is there's some misunderstanding occasionally between, you know, from whom does the First Amendment protect you and who gets to wield that power and so forth. And as a private institution, Ripon College and many small colleges like us really aren't bound in any way, shape, or form to follow the First Amendment, but I've heard you argue elsewhere that you believe private institutions should voluntarily adopt the parameters of the First Amendment. Could you explain your rationale behind that position?
And it's not only me, but the vast majority of private educational institutions, including Ripon, you'll be happy to hear, have in fact voluntarily chosen to adhere to essentially the same principles that they would be required to follow if they were literally bound by the First Amendment. And for those who haven't yet had the opportunity to take Steve's great course, let me just underscore a point which I think most people are not familiar with, that the Constitution itself binds only the government, with only one exception that's not relevant here. But so the First Amendment simply doesn't apply to a private company, a private employer, a private university. But most private universities say, as a matter of academic freedom, which is such an important element of a positive educational experience. So for the sake of our students' education, for the sake of the research activities and scholarly activities of the faculty, we are going to make a commitment to protect fundamental free speech principles. And therefore, not that I'm trying to plant any ideas in your head, because I'm sure free speech rights are completely protected here, but on the hypothetical assumption that you thought your free speech rights were not perfectly protected here, you could probably bring a contractual claim because the college, through its website and promotional materials and so forth, has enticed you here in part because of the promise that it would honor basic free speech rights.
So we can appreciate that colleges have a difficult situation in the fact that they've got to balance simultaneously their desire to uphold the free speech rights, but at the same time have to maintain an environment that is conducive to learning. So that can be a tricky balancing act. What kinds of suggestions do you give for institutions of higher learning to be able to pull that off?
And even the most ardent defender of freedom of speech would never say it is absolute. It's just that for the government, or for that matter, a private institution, to restrict freedom of speech, it should have a very important and persuasive justification. The primary mission of a college is education. So certainly any restriction on speech that is consistent with the educational mission is completely justified. In my class, and by the way, I also teach at a private institution, in my class, I don't let students read anything they want. I choose a syllabus, right? And the law school as a whole chooses a curriculum. You could say, well, you're censoring books that aren't on the syllabus or courses that aren't in the curriculum, but we do that not because of discriminating against a particular viewpoint, right? So we're acting consistent with that viewpoint neutrality principle, but we're doing it for an important educational purpose. In my law school classes, I tell students that as part of their professional training, they may voice whatever viewpoint they want. So I'm not discriminating on the basis of content. Indeed, I require them to articulate every plausible perspective on every issue we discuss. They cannot pass the course without doing it. But they must do so in language that is respectful and civil, suitable for use in a court of law. And that means that I'm no longer going to use what goes on in Congress as a standard of civility.
So a little bit more specifically, in the past few years, there have been some really high-profile cases of colleges and universities either inviting or disinviting, for lack of a better word, a controversial speaker. What kind of advice would you give to colleges and universities for contending with those types of situations where students might feel they're bringing in a racist speaker or something along those lines?
So
how should they handle it?
Okay, so first of all, it's not required that colleges choose to have what is called an open forum or a public forum approach to speakers. Colleges could, in advance, say, we consider this to be a rare opportunity, just the way not every course can be in the curriculum, not every book can be on the syllabus, not every speaker should get a platform on our campus. For some reason, a number of universities have chosen that basically there doesn't need to even be any connection to the campus. They basically let, on a first-come, first-served basis, anybody who pays a certain rental fee can come and use their facilities. Once they have instituted that policy, they are completely bound not to discriminate on the basis of ideas, and the answer to students or others who are protesting is to say what is literally the truth. We're not endorsing anything. This is a first come, first served, sort of like Hyde Park Corner, the classic example of a free marketplace of ideas. And just as the government, let's take an example in my home city, in New York, the government is not endorsing the ideas of everybody who stands on a soapbox in Central Park or holds a placard in Central Park. Indeed, it couldn't, because you're probably going to have people with exactly opposite ideas on different sides of the park. But if a student group has invited a speaker whom others see as disturbing in other ways, there's wonderful advice that was given by a terrific organization called the Southern Poverty Law Center, which specializes in monitoring hate groups, and it's done that since the 1960s. Because of the increasing recruitment efforts of white nationalist and white supremacist groups on campus, last year the SPLC put out a guidebook for students, you can find it online, what to do if the alt-right is coming to your campus. And it gives very, very constructive suggestions, including starting with going to the student group, or maybe it was in some cases it's a faculty member even, who has invited that person and trying to persuade them that they should voluntarily retract the invitation, because it's conceivable that they might not have understood how upsetting that speaker is, how little of value that speaker has to contribute to the campus discussion. So I would not rule out that possibility. A really, really important point that the SPLC makes, and I agree with this, is while it may be morally satisfying to engage in confrontational protests, and it may make us feel very virtuous and let off anger, that strategically that is often, if not usually, a very bad tactic, because often that is what these provocateurs want you to do, because it gets them attention and sympathy, including from the media, that they otherwise would not have had. So one of the alternatives is to just ignore them, and then it's going to deflate their expectations, right, if they're speaking to an empty room. You certainly do have a right of non-disruptive protest, and even more positively, to have your own counter event.